Good morning, everybody. Thank you for making time to join us today. Today's topic is how weather claims can be successfully brought forward for cost impacts caused by the pandemic. Unfortunately, we are still in the middle of this difficult time of COVID measures. As such, we have to meet digitally. In the meantime, we put together a great panel. Here to introduce the panel and to moderate the discussion this morning is Glenn Ackerley. Glenn is a partner with the law firm WeirFoulds in Toronto. He is chair of the Construction Law Practice Group. Glenn fills the role of project lawyer, providing ongoing advice to public and private owners, developers, contractors, subtrades, suppliers, and design consultants. Glenn is on the executive committee and a fellow of the Canadian College of Construction Lawyers. He has been recognized as a leading construction law practitioner in the Canadian Lexpert Best Lawyers in Canada and Chambers Canada directories. He's active in the industry, participating on committees and working groups, including a member of the Expert Panels Advisory Group on changes to Ontario's Construction Act. Glenn sits on one of the National Advisory Commission councils of the Canadian Construction Association and is past chairman of the board of the Toronto Construction Association. I'm very pleased to welcome Glenn Ackerley as moderator of this panel. Glenn?
Thanks very much, Jeff, and welcome everybody. I'm glad you could all make it. Just before I introduced the rest of the panel this morning, I wanted to take a few minutes to just set the stage to explain why, what's brought us here. And of course, as Jeff mentioned, we're in the middle of a global pandemic, and that's what's leading to our topic. As we know, there's been waves of this pandemic. We're now in what they describe as the third wave. You know, it's hard to imagine, but just back last summer, we were in Ontario, roughly 80 cases a day. And now we're over 3,000 cases a day as part of the third wave. So it's really been a challenge, with this wave being the most severe, of course, because of the variants. So we've all had very challenging, difficult times over the last year. And the construction industry itself has not been spared. We've seen all sorts of challenges with the industry itself. Just in the last day, I believe, they were reporting a project at Queen's University in Kingston had 32 cases on this job site, which of course just shows that nobody's, well, immune in that sense from the impact of COVID. And we've seen shutdowns, of course, in the industry over this past year. We've had 3 of them where essential construction has been able to continue, but non-essential construction has been shut down. Those are mainly, of course, ICI projects. The most recent shutdown, of course, having started just a few weeks ago, back on April 16th, that we're in the middle of right now. And then we hear of municipalities that have been hardest hit, like Peel in Toronto, saying if you have an outbreak on your job site, we're shutting down your job site, even if it's one that's essential. And then that raises, of course, the question, who's going to be responsible on the job site for that? So we're really in uncharted territory. And what we found is, as we turn to construction contracts that govern the relationships among the parties on a project, these typical construction contracts don't address either a global pandemic, that's not written in the contract, or for that matter, its impacts. It's very unclear. There's been a lot of debate about responsibility for the consequences that we've all been facing the last year. Debate about the contractual terms, debate about which ones apply, what types of claims can be made. How do you demonstrate those claims? What do you need to show to be successful in making those claims? And then how do you bring the claims themselves? What do you have to do? Over the last year, it's interesting to think about what has actually been going on with claims. And so that really sets the stage, as I said, for this panel discussion. What we've done is brought together experts in the area of construction and construction claims to discuss those issues. And I'm going to turn to introduce the panel. So first off is Catherine Willson. She joins us as counsel from Goldman, Sloan, Nash, and Haber, where she practices construction law. And I should point out, she heads the environmental committee of the Toronto Construction Association as well. So in addition to construction, she has a varied practice. And I can say one of the most interesting things I ever learned about Catherine is that she also has expertise in equine law. It's hard to imagine a more esoteric area of legal expertise than in horses. So
I like to say I'm Canada's leading equine lawyer. I may be Canada's only equine lawyer.
There you go. So thank you for joining us, Catherine. Next, I'll turn to Andrew Heel. Andrew is a co-founder of Heel & Co., which is a construction boutique. And Andrew's been active in the TCA as well as the Canadian Construction Association. On the legal side, he's been both past chair of the Ontario Bar Association's Construction Infrastructure section, as well as the National Canadian Bar Association section. I can point out that Andrew and I actually went to law school together, and I will embarrass him by saying that he ended up settling in with his law school sweetheart. And I think that part of it was a long-term plan to produce young heels to fill his firm eventually as time goes on.
No more lawyers, only engineers going forward.
Well,
contractors.
Engineers. Excellent. And then Howard Krupat, I'll turn to him. He is a partner at the firm of DLA Piper here in Toronto. He heads up their construction practice. He also is the newly installed chair of the Toronto Construction Association's Allied and Owners Committee. So congratulations, Howard, for that, or condolences, as the case may be. Jeff kind of spoiled the next observation I was going to make, because he mentioned that I had been on the advisory panel for the new Construction Act. Howard was as well. So we worked together on that. And I was going to point out to everybody, if anybody's got complaints about the Construction Act, they can turn to Howard to file their complaints and by blaming him. But unfortunately, I'm kind of caught in that too, I suppose. Although I always use the excuse I was down the hall in the washroom when the worst things were passed about it. So that's the lawyers on the panel. Now we'll turn to our more special guest, the non-lawyer on the panel, Gerard Boyle. He's with Revay and Associates, and his expertise is really twofold. He straddles both the in-project work, providing consulting advice and expertise on project management, on scheduling, project cost controls, those issues to keep projects on track as they're being undertaken, as well as claims support at the back end in terms of forensic analysis of schedules and delay damages. So we're grateful to have you here with us as well, Gerard.
Thanks.
So those are the introductions. And now we're going to roll up our sleeves and get into the discussion. And the approach is going to be to break down the issues by having a roundtable discussion led by one of the panelists in each case. So we're going to start off the discussion this morning by turning to what the impacts of COVID have been on construction projects, what we're seeing as we look out at the landscape. What are the sources of claims? What are the types of things that people have run into and experienced? And to lead off this discussion, maybe I'll ask you, Andrew, to get us started. Tell us about some of the things that you have seen your clients experiencing on jobs. And then later we'll get into where we turn to deal with the claims that might arise. But what are we actually seeing?
Yeah, absolutely. Thanks so much, Glenn. I'm thrilled to be speaking with a bunch of my colleagues and friends. I've practiced with them, either with them or against them on many claims, not COVID claims, but certainly experts in our industry. So to get to what I think clients are seeing, I think a lot of uncertainty to start with. And the first thing is project extensions. There's uncertainty because, if we stop for a minute, I pulled out a year ago, one of the first things I wrote about COVID, pandemic globally. But I think we were all thinking it was real, it was very serious, but it wouldn't be lasting a year, so that here we are a year later meeting virtually. We have to meet digitally, but projects still get built in the real world. Projects being built in the real world, clients that I've been speaking with are talking to me both on, although I primarily practice on the contractor and trade side, but on the owner side as well. It's just uncertainty that's being reflected in the contracts in terms of going forward, but uncertainty about what to do, and certainly schedule delays. Project duration increases to me is the principal effect. I think it's a success story that we've had so few shutdowns. You just heard Glenn talk about Peel saying, we find it on your site, we're going to shut you down. That's going to have impacts when you talk about contracts, because there are specific clauses if you're using CCDC that talk about government orders. But it's not just shutdowns by government orders. You've had things short of that, increased PPE on site, supply chain disruption. Jeff Merva, who introduced us all, spoke earlier in one of our pre-panel sessions about experiences that he's had. I've seen small cost escalation, but certainly he was talking about escalation in steel and HVAC pricing in the vertical building industry in the order of over 20%. So we're seeing supply chain disruption, we're seeing cost escalation, and our contractual tools to deal with them, the old ones, the pre-pandemic tools, are going to have to be looked at again in terms of going forward. But in terms of claims today, you're stuck with the old language. Another point Glenn made was that it's a rare contract that has the words pandemic in it. And it's really only the large ones. I've seen it in the Gordie Howe Bridge projects, the contracts which predated COVID, but postdated SARS. So larger projects are writing in pandemic language, smaller ones not so. And the source of the claims is multi-fold. It's schedule extensions, it's PPE costs, it's a small number of shutdowns. It's certainly loss of productivity, and I want to hear certainly from Gerard on that. That's really his sweet spot. And it's important to remember that context is everything. Like, this is happening in real time, and what the rules were before are different than the rules today. Not just your contractual rules, but I mean what the Ontario government is doing. For example, here we are in a full shutdown, and you have to go to 2 or 3 sources to trace through what's essential, what's non-essential. The order's been extended to May 19th. It was supposed to, when it was first issued, April 16th, it was going to go from the April 19th to the May 19th. But essential construction continues, non-essential doesn't. And essentially, if you've got a residential project or related activity, if you were already building by April 17th, if you're building health and long care sector projects, or if you're funded by any of the governments, provincial, local, or federal, there will be an exception. But that creates uncertainty, and that's the fundamental point, uncertainty. And how is the best way to deal with uncertainty? That's something that we are going to talk about as we go forward. So I just wanted to introduce the topics and let my colleagues chime in.
Well, thank you, Andrew. And that's a good list you've created right out of the gate in terms of the types of issues that create the uncertainty, as you point out. The delays, even the definitional uncertainty around essential versus non-essential, as you said, that's not always clear. Howard or Catherine, anything to add to Andrew's shopping list before we turn to the contracts themselves that are in play? Howard, have you seen anything to add to Andrew's list?
Sure. A couple of quick comments. I think Andrew's given us a sort of a pretty comprehensive overview. But one thing that I think the industry ought to be commended for, that I've seen on a lot of projects, is whenever an illness issue arises that's potentially disruptive to the project, I've noticed that the first thing clients ask is, what do we do to protect the safety of the workers on site? What are our obligations to report this? Do we have to consider shutting down, or what measures are we required to implement? And I've been really impressed by that. So although we're talking about sort of claims being our focal point today, one thing that I've really seen in the industry is people really looking out for the safety of the site supers, the laborers, everyone on site whenever an issue arises. And worker illness certainly has come up, obviously, during the course of the pandemic. So from time to time, I'm contacted when there's a potential breakout on a construction site, and you get those kinds of questions. And I think the appropriate approach, which is consistent with what I've seen, is first, what do we have to do to protect everyone's safety, and secondly, how do we deal with the impact upon the project? And when you're talking about the impact on the project, and we'll get into this more a little bit later, often the first source of information is going to be your contract documents, because as Andrew pointed out, the contracts that we're dealing with, whether it's the CCDC contracts or custom contracts, just don't contemplate a lot of these things. And we're going to get into that in a little bit more detail down the road. In today's discussion, but just to highlight one of Andrew's comments, I think when we talk about material escalation costs, that's certainly something that we don't see in some of the standard contracts, and that presents a real conundrum for parties. We've all heard that the costs of lumber, for example, have gone up, I don't know, I think by threefold or something in that range since the beginning of this pandemic. And if you have a fixed price contract, are you entitled to assert a claim for that, or are you stuck? And you could be stuck depending upon what your contract says. So it's really important to look at the source document.
Well, thanks, Howard. And it's true. I know the Canadian Construction Association has stepped in because this is a national problem, the price escalation challenge now, and they're working on education and promoting solutions to that problem, because it is a contractual issue that needs to be worked out. Catherine, anything to add before we move on to looking at the contracts themselves?
Yeah, I have two short comments. One is, will this change the type of construction moving forward? Are we still going to need office towers? Are they going to be converted into something else? What happens with industrial and warehouse? What about refrigerating? HVAC people might be very happy over the next bunch of years. So that's one. How does this impact the type of construction going forward? And two, a good news story, video technology. We're doing drone tours. We're doing virtual tours. We're doing virtual meetings. We're saving so much money on site meetings by doing it this way. I think this is going to be a cost saving for the industry. And we were a bunch of dinosaurs, so we're being dragged into the new world. And virtually, I think that's going to be a real boon for this industry.
Well, I would just, let me turn it to Andrew. You want to react to that, but I agree that it's worth underscoring, as you've done, that there have been the technology improvements. We've been forced to be more efficient, more, in many respects, forced to be more technologically savvy as a result of this. Witness this panel discussion virtually, but that's having an impact on construction and will going forward. Andrew?
I was just going to support what Catherine said 100%. I think the digitization and the dragging, as she said, into the modern age, coming into our office, you fill out the JOT form, which says you're COVID free, and it happens at the building coming in and happening on site, that sort of thing. But you need records, and you need them to be digital, and claims are going to become more digital. But it's the industry taking care of itself that I just wanted to, you mentioned the CCA. There's a new protocol that came out April, I think it was 19th. It's version 7, and I commend that to everyone, which is best practices, because claims aren't just one way. So there's not only claims that you bring upstream, but claims that you receive from downstream, but also particularly if you're not taking care of your workers and staff as number one, there can be other liabilities associated with that. So you've got to meet your best practices, both to protect your team because it's good business and because it's the right thing to do.
All right. Well, let's move then. We've touched on it, danced around the contracts themselves that are a little deeper into that topic. What are some of the types of clauses in the standard CCDC family documents, for example, that over the last year, the industry and perhaps even more accurately, the lawyers have been looking at when they're trying to figure out what hooks do we hang these claims for consequences because of COVID onto? What are the various sources of legal support in a contract that we can turn to? So maybe I'll ask you, Howard, to lead off. What have been sort of the top billing items that we all debate and write papers about, certainly back starting last March when all of this hit? What did we see as the top sources of potential recovery or in contracts?
Sure. So thanks, Glenn. There's nothing I think that gets anyone more excited than when a lawyer starts tossing around Latin terms that they learned in law school. That's a great way to get everyone's attention. But that's what's happened here. So everyone's familiar with this term force majeure that gets thrown around on construction projects and all kinds of contracts for many years. But it's never gotten more attention than it has over the last year. So there are clauses in contracts that speak to this often. So what's a force majeure event? It's an event beyond the contractor's control typically, but the party's control that prevents a party from performing its contractual obligations. Now, a lot of people are surprised when you get into this conversation to learn that there's not really in Canada an accepted legal definition, the common law definition of what force majeure means. So if you don't have a provision in your contract that talks about one of these events that's beyond everyone's control, that's impacting the parties, it's really difficult to try to figure out what's going to happen. So many of you have heard of this term referred to as in the past, typically, an active God. So it's so rarely becomes the focal point that the last leading case from our Supreme Court on force majeure clauses was in 1976. So that's what we've been dealing with through the COVID crisis. Now, Glenn, you asked about the CCDC contracts. So the CCDC contracts don't use that phrase, but they have provisions that deal with what we think of as force majeure events. And the interesting thing is that those provisions are different depending upon which form of CCDC agreement that you're looking at. So you mentioned that people have been writing a lot of articles in the last year. Well, one of everyone's sort of favorite topics in these articles has been GC 6.5.3 of whether you're looking at the stipulated price contract, the CCDC2, or the construction management contract, the CCDC 5B. It's in the same place. And that's the provision that says that if there's an event beyond the party's control, then the contractor is going to be entitled to certain relief. Now, it's really important to look at what version of the contract you have, and of course, if you have supplementary conditions, that just go ahead and delete the whole thing or modify it. But in a CCDC2, for example, the contractor is entitled to an extension in time if there's a force majeure event, but not entitled to additional costs. If you're under a construction management contract, the construction manager is going to be entitled to time and also an adjustment in their overhead costs. That's in the provision. But then there's been a lot of debate within the industry over the last year about whether this pandemic has constituted an event beyond the party's control that's caused an impact upon the project for those non-essential projects that haven't been shut down. So that's one area of focus that you have to look at under your contract. Has my contractual obligation been made impossible as a result of the pandemic, even though I'm not an essential project. Sorry, I am an essential project and my project is still running. The other big source of discussion has been GC 6.5.2. again, in both contracts. And that's where you see this phrase that I think either Andrew or Glenn mentioned earlier, stop work order. The phrase isn't defined anywhere in the CCDC contract. You'll see it in lowercase letters, the term stop work order. And if you have a stop work order, so if the project is shut down as a result of an order from a governmental authority, for example, or by a court for a reason so it's beyond the contractor's control, then the contractor is going to be entitled again to certain relief. There's been a ton of discussion over whether all of these regulations and orders that we've heard about over the last year constitute a stop work order. So the argument has been, some would say, no, that phrase was always intended to apply to a very project-specific order. So if a ministry comes along and says, this project has to be shut down, whereas the other point of view is, no, look, this is an order issued by the government. The project has to close as a result. What else could that term mean? This is clearly a stop work order. So in my practice, I've seen claims advanced on the basis of that language where the project has had to be shut down. It's a very common basis of asserting a delay claim in the course of the COVID crisis. I haven't really seen it tested in the sense of a court decision on the interpretation of the stop work order phrase, but what I have seen is a lot of these claims have settled because parties have been. Another thing that I think the industry should be commended for is that, you know, parties have recognized that the pandemic is truly something beyond the parties' control, that everyone's got to live with, and there's been an effort to try to sort of negotiate and resolve these disputes. But sometimes you've got these additional costs. You have to assert these claims. You have to be sort of compensated for the impact that you've had, and these are the provisions that you have to look at. I'll mention one really quickly because I've taken a lot of time on this topic. Another common debate is because we're talking about the standard form contracts, is GC 10.2.7, which talks about, which is the so-called change in law provision. So there's a lot of debate around whether when the government has issued these orders and directives, that is a change in law that would entitle the contractor or the construction manager to relief under that provision. And there are opposing arguments on that as well. I can tell you again, in my practice, I've seen that come up quite a bit as the basis for a delay claim. And the argument is, look, like these orders, these regulations were not in place when we started this project. The pandemic arose, these new regulations came out, we were impacted and were entitled to relief under the contract. The argument against that provision has come from those who say, well, those regulations are more of a description of how you comply with your obligations under the Occupational Health and Safety Act to protect the safety of everyone and the health of all the workers on the project. So again, we don't have a court decision that tells us, how that's going to work out. Certainly, though, a lot of claims and negotiations had been advanced on the strength of those provisions.
Great. Well, thank you, Howard. And it comes back to what Andrew pointed out for all of us is just the uncertainty around all of these issues. And so the three legs of the stool, if you will, that we're dealing with on the claim front under contracts, Howard, if I can just sum up, is either it's out of the party's control, force majeure, but of course that leads to an extension of time, but not necessarily any compensation. And if you've got projects that have been continuing because they're essential construction, it's unclear whether that clause has any effect because they weren't actually shut down entirely. They limped along. And so that complicates that. Then there's the stop work order interpretation. Does that apply or not? Is a government shutdown order actually a stop work order? And finally, change in law. Maybe a change in law, new requirements, health and safety requirements, but maybe just simply recommendations you're supposed to follow as a general contractor being the constructor on a job anyway. Whatever it takes, you have to do without compensation. So even contracts then are unclear. But if you are going to bring a claim, Catherine, I'll turn to you. What is probably the key essential starting point? in all contracts whenever you've got some issue? What would you say is important that everybody listening today appreciates when they turn to their contract and they've got some compensation or entitlement that they want to pursue?
Okay, well, borrowing from a motto of the TCA some years ago, thou shalt know thy contracts. So first and foremost, know your contract. Whenever there's an issue, not even just COVID, anytime, pick up your contract and read it, because you cannot claim in many instances in a contract if you have not given written notice of the claim. And there are deadlines in many of these paragraphs for written notice. Under the CCDC 2, there's a 10-day deadline for notices of a delay claim. If you want to suspend your work or terminate your work as a contractor, you have to give notice and then allow for a 5-day period for the owner to try to rectify. Under some of these, it just says timely notice in writing. This is a claim for a change in the contract price. Somewhere else it would say reasonable notice in writing. But I guess the important takeaway from what I'm saying is in the provisions where it says 5 days, 10 days, 3 days, if you don't give notice, there's lots of case law that says you're out of luck. So COVID could have happened in March. You're dealing with the worst of it in June or July. You give your notice, that could be a real problem for you. And
No, go ahead.
So my recommendation is whenever you think there's going to be a delay, if you think there's going to be an extra cost, if you're worried about it, just send an email with notice saying, we believe there's going to be a potential here for increased either cost or time, right? We're talking about cost or time. Send the notice. You don't have to send it every second day. The provisions say if it's a reoccurring thing or if it's an ongoing thing, one notice is satisfactory. Again, read your contract. And the only other caveat I'd tell you is the supplemental conditions, because everybody's got supplemental conditions and they're going to say something else. They may restrict the notice. They may have other claims that you can claim under, or they may reduce your ability to claim. So read the supplementary conditions and see if they modify in any way the notice requirements. So know your contract and just send a friggin' notice. Doesn't hurt you.
Send a friggin' notice. That's what the takeaway is. Just before I turn to you, Andrew, I wanted to just also point out that in terms of timeliness of notice, which is such an important point, Catherine, is that another area of timely notice you have to be aware of is even if you submitted a claim and the consultant, or depending on the contract we're looking at under subcontract, the contractor has determined that you are not entitled to the relief that you're seeking. Whatever you're claiming, they dismiss. If you're going to dispute that, there is another section of your contract you have to look at very carefully to object to that decision within a period of time and commence the dispute resolution process. Because if you miss that window, you're deemed to have accepted it and you lose your rights too. So it comes back to your theme, Catherine, of read your contract, find those time windows that you have to comply with and make sure you meet them. But before we leave notice, I want to get thoughts of others and I open up to the panel, but I wanted to hear about your experience with what goes in the notice, because that's, Catherine's absolutely right. You've got to be mindful of your time. Contracts often say what's to go in the notice. And I come back to you, Andrew, about uncertainty. What do you say in your notice when you don't know what's going to happen? I think I'm going to be affected, but, so that raises a bunch of questions, I think.
Yes. So I still think Catherine's got the best line of the morning, and I want to hear from Gerard. I'm not going to say we're over yet, but put your friggin' notice in. If there's one thing you have burned into your heads, I think she's done it for us all. But what do you put in the notice? Certainly, in the CCDC, there's a little phrase there, timely notice or notice in writing. Notice in writing is defined, but I think it's broad enough to include email. But you've got to put the basis for the claim. It does ask for the amount claimed. My own view is I think you can get away with not putting it in because of the uncertainty. And then just to throw a little bit of a curveball, and I still think we have to remember to give the friggin' notice. But even if you don't, I think the hook of change in law in this pandemic is so different from what those clauses were intended to cover. I don't think you are, speaking plainly, SOL, but it's going to be difficult because the purpose of the notice is to give the responding party the opportunity to do something to mitigate the cost. Very little you can do. And then the other point I want to make is just about what was said before about force majeure is be careful about the remedy for force majeure, in my view, is contracts over kind of thing, right? Because it can't be performed anymore. Nobody wants that. The owner doesn't want that. The contractor doesn't want that. So really at the root of force majeure, the 1976 and backwards cases are about something that makes the contract unable to be performed at all, as opposed to more expensive to perform, which is, I think, where we are in COVID, and more expensive to perform. I'd like to hear what Gerard has to say about that as well.
Well, that's
Sure.
a good segue, Gerard. I was going to turn to you. You've been very patient. I've been not ignoring you, but about to turn the spotlight onto you. Feel free to pick up on anything anybody said about the topic so far. We've been talking about contracts. We've been talking about particularly notice periods in contracts. But what I want to do now is turn to the claims themselves that arise out of the COVID situation that we've been touching on, and what you see in your role of from the project side and also a claims analyst side of how you actually go about dealing with the data that you have to collect and how you go about packaging up a claim. Assume you've given the friggin' notice. What is it that contractors and trades on projects are claiming, and how do you support that claim? So help us there.
Sure. I'll pick up on notice because it certainly connects to what I'm going to talk about here, which is, how do you handle these things and put together a claim? I write specifications, schedule specifications for owners often that end up in the contracts, including CCDC contracts. And what part of that spec says is that the schedules you produce will be the instrument that you use to demonstrate to the owner at the time that you're having an effect. So the question is, and the lawyers will all have a take on this, what is sufficient notice? And my own take from working for owners and contractors is that there needs to be, if you're going to give notice and it's possible to quantify what you're talking about, by all means quantify, but at least the nature of the problem should be translatable to a schedule of some sort. I think that becomes a part of it. You do your brief written notice and there you go. But let me now move on to the whole issue of, all right, how are you going to put a COVID claim together? And I want to start by the whole issue of what the productivity effects of COVID as we know them so far.
Mm-hmm.
And there's a couple of studies out that I've seen. They're preliminary. One is in the U.S. It's the Electrical Contractors Association, the Mechanical Contractors Association. They've arrived at a conclusion that it's actually adversely affected productivity on their projects by 18%. There's another UK study that's as high as 35%. Now, if that's anywhere close to being true, then construction costs are going to be equivalently increased and projects are going to be delayed. So I don't need to tell anybody on this line that this is a serious problem that not only contractors have, but the whole industry has, and we all have, because of the cost of construction is going up like that. We're going to have to pay the bill at some point. So with respect to the answer, okay, how do I quantify something like that, the effects of COVID? What would be expected? I if you don't mind, as a non-lawyer, I'm going to cite just some summary opinions about what is needed from my perspective as a forensic analyst to demonstrate it. Because the same approaches you take with all other kinds of delays, even though the entitlement question of COVID is very complicated, a lot of the approaches that you're going to have to take to demonstrate it, they don't change. Here's a few case study conclusions or legal case conclusions that I'll read off to you. One said, we have found, had the contractor submitted and updated a resource-loaded CPM schedule as required, the contractor could have tracked disruptive impact through the schedule. That's one opinion. Here's another. 20 years ago, a contractor might justifiably have taken the position it could not foresee any sort of productivity impacts. We consider more plausible now that the complete cost of a change, including impact, could be estimated. Yet another one. Delays and time extensions need to be evaluated with accurate CPM schedule updates. A different decision. The CPM schedule should be updated periodically to improve the accuracy of forecasting and provide a schedule of the remaining work based on actual conditions on the job. The Federal Court of Claims in the US had this to say: schedules on a project are of such importance that refusal to comply with contractual requirements regarding submission constitutes a material breach of the contract. And the last one I'll cite is a Canadian, this is actually a Superior Court of Ontario decision. And the master in that one said, the analyst's self-described as planned versus as built schedule analysis methodology cannot be relied upon as presenting an accurate picture of the critical path, and accordingly is also unreliable in how contractor losses and damages from project delay were allocated. So what happened in this one, the analyst was saying, the forensic analyst who does what I do, take my judgment about what is critical instead of using a CPM schedule to demonstrate what is critical. The master decided, about that approach, I am left without expert assistance to determine the extent to which, in this case, Schindler elevator caused or contributed to critical path delay, if at all. So I'll just, the next minute or two, Glenn, what do we take from all this? There's a bunch of court decisions, and all of them are quite consistent in my view as far as what you have to do as a forensic analyst. So how do we manage COVID claims? It turns out that the monthly CPM schedules that you're required to produce by contract are the preferred instrument to analyze delays. So you guys have those things with you. You don't need to get a forensic analyst like me in to do those. You know, just do them. Don't wait until the end to claim. You put your money at risk. It's hard to tell a reliable story at the end, and project performance might have been improved if the whole issue had been dealt with at the time. Understand that if there is an effect from COVID, it should be quantifiable. I don't mean here, of course, the job could get shut down in 2 weeks. That's a different story. But if your productivity is impacted, that's quantifiable and demonstrable. Be sure to produce the reliable monthly CPM schedule updates that your contract requires, and do your best to get the owner to accept them. As you probably know, on great many projects, that schedule never gets accepted, and it kind of, people put it in the waste paper basket. That's risk to you guys as contractors. For each update, if you're going to do it, take a couple of hours, not more than that, to analyze the month that just finished. And in your narrative, if you've been affected, say so. There's your starting point of a record, right? Your memory is fresh, the facts are available, the complexity of events in 1 month is manageable, and you'll have documented your position, as I say. Even if the contract doesn't require resource-loaded schedules, understand the baseline labor assumptions for all the key trades and how actual productivity and resource supply is differing. This is just good construction management practice anyway, and you need this kind of information to advance a productivity claim, which may also affect time. Another suggestion is, we've talked about some of the types of COVID effects. You might create in your accounting systems account codes to track things like COVID safety and training, COVID distancing and access limits, cleaning and disinfection, remo. Get it in, there's a real record. It's going into something in your cost report. That's something as well. Do all of this, and you have a strong basis to advance your delay and productivity claims at the time they occur, and that's the key. Do it at the time. Finally, last suggestion, you might try and wrap all this up at the time, and we're going to talk about this a little bit, into some kind of commercial settlement process. So if you have a bunch of owner-caused delays that it's making your life difficult to even put a schedule together, tie the two things together. I often get involved in this kind of commercial settlement, where you say to the owner, look, we'll work with you. You give us information on design or whatever's missing. to finalize the schedule for the remainder. And at the same time, you're going to evaluate our claim, and we're going to try to get this whole thing done at once and have a fresh start for the remainder. So that's kind of my general feeling about the approach here.
So thanks, Gerard. That's great. So give the friggin' notice and update the friggin' schedule.
Yes,
Where we've gotten so far.
absolutely.
Excellent. So maybe, and you set it up nicely, we should open it up to everyone to talk about, you mentioned commercial settlements. Howard, earlier you alluded to it as well, that you've seen these things worked out, being worked out by the parties. Part of that, I suspect, is, again, back to Andrew's observation about the uncertainty, not just about what contract provisions apply, what a court may say, because that we haven't had any precedents yet, really, that you can turn to. So in this era of uncertainty and competing views on things, we're seeing settlements. But let's talk about, I guess, two aspects. One is, what would be the processes you might use to pursue a claim, but then what do we see really happening on the ground in terms of those? So why don't we open up, maybe Catherine, you can start. What have you been seeing?
Okay, well, just a couple of comments on that other issue. One idea I saw from the US in terms of productivity being impacted is to take kind of a setting of what productivity meant in previous contracts and look at productivity today. I think I saw the same article, and they said the average worker loses 50 to 60 minutes of time a day because of COVID and COVID related things. So it's kind of nice to see how your product, you can do a benchmark and you can compare previous jobs to your current jobs. And then you can use that percentage of increased productivity lost to forecast on your current jobs, what's going to happen going forward, and on future jobs, what you should build into your bid in terms of lost productivity because of this new age, at least for a few years. So that's a comment I'll make. So in terms then of what do we do? How do we approach these issues? I think the thing, what we're seeing in Canada is that we're just talking. Owners are talking with contractors, are talking with subtrades. We all recognize this is an unusual, highly unusual situation. What can we do to work together to continue the project, knowing that there's going to be a financial hit for everybody involved? And I think, we believe, many people in Canada, many businesses are solving these problems just through discussion and negotiation. If that doesn't work, you can go to your contract and you can choose mediation and get an experienced mediator to help facilitate a negotiation of a settlement on these costs. If that doesn't work, you can go to arbitration. If that doesn't work, you can go, or you can go to the courts. Another idea on your newer contracts is this adjudication process, which is the new Construction Act. And in 30 days, you have an adjudicator who's going to render a decision, and it's fast, it's quick. There's not a lot of it out there yet, but at least if you can't even get the discussion started with the owner and you're worried, send in that notice of adjudication if you have a contract that qualifies, and it gets the conversation started. Because in 30 days, someone's going to be making a decision if you don't have that conversation started. So you can bring people to the table using that as a tool. In the US, I've been noting there are quite a few lawsuits already out there about these cost issues. And they're looking at lost productivity, pandemic, mitigation tracking systems are being used. It's huge in the US. It's not here yet. We're still quite a small shop. And we're mostly getting along in the sandbox, I would say, but that's not to say it's going to continue. The only other point I'd say is don't wait to the end of the contract. Adjudications can't be done after a contract is completed, so you're out that remedy. And there's less incentive for everybody to find a solution if the project's completed and the owner's sitting in their building quite happily. So don't wait, and do it while you're in the middle of construction, and do it at the beginning of construction. When you're tendering things, sit down, have those discussions. If it's not in the tender documents, raise a question. What about these 20% extra productivity costs and material costs? Huge. Yeah. How are we going to deal with material increases through the project, and get the owner to put it in the tender documents so that the project runs smoothly? Because we're all about smoothly and everybody making money. That's what this is about.
That's great. Andrew, sorry.
Yeah, go ahead. I was just going to say, Glenn, kind of following on one thing that Catherine mentioned, which I fully agree with, using these studies to some extent to help you to try and quantify or carry some costs for all of this. It should be clear, though, as far as demonstrating productivity, it's a weak approach to use any of the standard empirical studies. What you're going to need to show, and even during a job, if you really want to push it, is real data about what actually happened on your job.
And that's the challenge, isn't it, on that if you're not in the practice of tracking that kind of information you've been sharing with us, Gerard, about what should be followed. If typically you don't, once you've hit COVID and you're being impacted, the productivity is dropping.
Yes.
To prove that it has, you have to have the data of when it wasn't affected.
Yes.
And that data can be a bit of a challenge to create after the fact if you weren't keeping proper track along the way. So no question that these claims are a challenge to present if you haven't got the proper record keeping and been tracking it. But in terms of the back to what you've been seeing in terms of how the claims are either pursued and then perhaps resolved, maybe I'll turn to you, Andrew. What have you experienced so far with your clients?
So I still think a recipe for successfully managing claims is reaching out to your counterparty. So that takes place primarily through negotiation. And lawyers shouldn't be to drive people to the extremes. They should be to bring people closer together. Whether it's a negotiation or a mediation, as Catherine says, which is really a facilitated negotiation. It takes place in the shadow of the law. There's going to be some uncertainty, but that's on both ends. And it's better off keeping control of the process. So my process of choice really is mediation, and the sooner the better. It's certainly during project performance is still, despite the fact that that's been in CCDC, I don't know, 2008, at least for a decade and a half, maybe longer. Mid-project mediations are still more of the exception than the rule. I think they should take place. And the benefit of that versus adjudication is you're keeping the relationship as the main goal. The goal is to keep that relationship positive. And so whatever you're doing, whatever dispute resolution tool you choose on the spectrum from negotiation, mediation, arbitration, adjudication, more on that end, court on the furthest end, choose a tool that keeps the relationship positive and in focus and in control of the outcome, which is where I think when your claims are uncertain and the resolution of them are uncertain, keeping control of the outcome is important.
Howard, what have you seen? We've heard from both Catherine and Andrew the benefit of mediating the dispute along the way to keep the relationship going. What's been your experience so far?
I agree with all of those comments, and as I alluded to earlier, I think I've seen on a lot of projects, contractors and owners have been working well together to negotiate a resolution to these claims. I've seen some getting resolved at mediation, which I think is a positive thing. It's an early dispute resolution process. I personally haven't seen a COVID claim go to adjudication, but I think that's a potential possibility if you've got if it fits into one of the criteria under the Construction Act for an adjudicable dispute. And then there are a lot of great comments to pick up on from what we've heard from Catherine and Gerard and Andrew, and we've only got a minute or two left. I was kind of chomping at the bit on some of these things, so I won't start going on and on. But there are a couple of important
things. You can file a claim for extended duration, but I think it'll be denied, unfortunately.
Well, there's one point in particular that I want to draw out of all of that, which is that advancing these claims could be complex and difficult, and so you've given your friggin' notice, you've updated your friggin' schedule, and then you call Gerard and he puts together a binder of information, sort of backing up all of your costs and schedule impacts. But what happens when despite all of that compelling information, you don't get your dispute resolved through those negotiations or through that mediation process, and then you find yourself before that arbitration panel or in that court process, you've got to prove not just that you have a binder full of costs that have been incurred, but it's interesting. It comes back down to what that contract says and whether you've convinced the court or you've convinced the arbitrator that you're entitled under this contract to the costs that you've compiled, whether you're trying to represent them through industry studies or, as I agree with Gerard, preferably through actual data is much better. And that's where the claims consultant and the lawyer really have to sort of sort that out together, and to make sure that as compelling as your case might sound and as overwhelming as these damages might be, you've done everything you can to kind of meet the standard that the court's going to require to show there's an entitlement under the contract, the damages that you're claiming flow from that entitlement, and that your counterparty is obliged to pay you for that. And those are kind of rudimentary things that the court or the arbitrator is always going to come back to, even in a very compelling case. And sometimes we all tend to lose sight of the importance of those things. And it's easy to summarize. It's difficult to meet that threshold, and it's really important to always keep that in mind in the course of assembling your claim.
Well, that's a great summing up, because it brings us full circle to where we started. We talked about the claims, but can't lose sight of the fact of the contractual framework that all of this is happening under, and we got to always be mindful of that, look back at that. So with that, I see John has joined us. We've reached the stroke of the half hour where we it may seem like an hour from when we started. So I'm going to turn it over to you, John. Just to sum up, first of all, thank you all panelists for all of your insights, and appreciate you all participating and sharing that your experiences and wisdom. John, why don't you have take the mic and share your comments at the end?
Thanks, Glenn, and thank you all. I think everybody who has been fortunate enough to attend this morning will agree that it's been an extraordinary panel, not only because of your collective expertise, but I think you've helped us as contractors better understand a bunch of things that were very unclear. I don't think any of us believe for a moment that the uncertainty will disappear, but I do think you've been very good at helping us understand that it isn't just about, say, force majeure, whether our contracts have force majeure language, and whether COVID is a force majeure event, and the impacts of that are probably more schedule related than the costs that arise because of COVID. But I think Howard pointed out, and all of you spoke about it, 6.5.2, which is the stop work order language in most CCDC contracts, unless it's amended by supplementary conditions, that the government order to shut down may, for example, constitute a change, something that could be viewed as a stop work order. We've also talked about 10.2.7, the change in law provisions. Lots of confusion about where you park your argument. I think all of the lawyers made the point on the panel that begin a dialogue. Get your notice in straight away. I think our owners, buyers of construction recognize that these are things that were well outside our control, that weren't contemplated when they tendered projects. Most are willing to have a conversation. I think, Gerard, you made the point very well that it's important to start that process early, that it would be reflected in CPM schedules in terms of impact. And that's primarily schedule impact, but that to the degree you can, separating some of these things out so that we accrue some of the costs on a monthly basis that arise because of the impacts, the productivity impacts, it certainly improves your chances of defending something, an argument that you would like to use to advance a claim. So I, for one, have learned a ton today. Glenn, as always, you're an extraordinary moderator, and I thank you for keeping things moving. To Catherine, to Andrew, to Howard for your extraordinary legal advice. Gerard, as a claims consultant, you shared some real insight, I think, that will help our members. And I really genuinely believe you've been extraordinary. Thank you all. Just in terms of what now happens, we, as you know, we've broken Members Day into kind of a 2-day thing. So tomorrow we have the trade show portion. For those of you that haven't been on our website, in our events calendar, you'll see a chance to register. Please do that before 2 p.m. today. And what will happen is you'll receive an email once you have done that, and you have to re-register so you're set to go for tomorrow. As an exhibitor, you would start at 9 tomorrow. That exhibitor group is full, or you can't now join as an exhibitor, but you can join as an attendee, and that begins at 2:30 tomorrow, ends at 2. It is very worthwhile. We've got some extraordinary exhibitors, and it's all part of our best effort to give you a virtual Members Day, recognizing that in person is impossible. We all hope we'll get back to that one day soon, but we look forward to having you on tomorrow. And I think the group today has been extraordinary, and I thank all of you. So thanks, folks, for joining us, and thank you, panelists, for enlightening us.
Thanks, John. Thanks, everyone else.
Thank you.
Stay safe. Bye-bye.
Bye now.